I'm really glad to give the floor now to Mr. Hasan Kakaya. Хасан, декілька фраз на початок з вашого боку про тему нашої панельної дискусії. А тоді передамо слово вже і пану Фредеріку Жені. Пан Фредерік, як голова Комітету з питань конкурентної політики ОЕСР, розповість деякі загальні відомості про те, які є статус, які найкращі глобальні практики про розвиток конкурентної політики. I'm sorry, I was not waiting for the interpretation. I will give the floor for Mr. Hasan Kakaya, who is the co-moderator of this session, and a couple of words to open our topic, and then I'll give the floor to Mr. Frederic Genie, who, as I already mentioned, is the head on the competition policy of OECD. And I would ask Mr. Frederic then to tell what are the best world policies, best world standards as for the formulation of the implementation of the competition policy.
Thank you very much, Yuri, for the introduction. I won't say anything other than say that on behalf of the Comparative Development Foundation, on which I'm sitting here today, we are extremely happy to cooperate with the Anti-Monopoly Committee in organizing this event. The foundation is an advocacy. It's a non-partisan, independent agency working on the development of competition issues in Ukraine. It is clearly pro-market, pro-consumers. And to that extent, we are very happy to participate in this work. Thank you very much.
So, Frederic, let's get started with basically with the subject matter of our first panel, competition policy, inclusive, comprehensive competition policy as a foundation for the economic development. I think your experience, your advice is...
розвитку. Я думаю, що ваш досвід, ваші поради будуть дуже цінними для нас. Отже, будь ласка, які зараз існують кращі зразки практики, кращі стандарти глобальні. Дякую дуже, шановний пане голово.
I will try to cover a number of issues because the topic of this is pretty wide. So to cover a number of issues from the point of view of international experience, what we have seen in other countries and what reflections that leads to when one thinks about Ukraine. My first comment, though, would be to remind everybody, and this is because it's a compliment to what you said earlier, the reason why we are gathered here today, I guess, is not so much that Ukraine has international obligations to push competition law, but it is to make sure that the market economy of Ukraine ensures that there is compatibility between the individual incentive of economic actors, whether they are consumers or firms, and the social benefit. And for this, we need a framework. And the framework is the competitive framework we know from economic theory. So we have to work collectively to make the economy as vibrant as possible and as useful as possible, and that is why we think about competition. Now, there are also international obligations, but those international obligations derive from this collective wisdom that we've learned in many countries. The second thing I want to say is, as an introduction, is that I'm quite impressed by the progresses which have been realized in Ukraine over the last year. I was here about a year ago for a previous edition of this conference. I can see that the competition authority has become a highly respected, active, and institution, and an institution following best practices. I noticed that there are a number of guidelines which have been published. There are some others who are in the works to try to make the legal environment more secure for firms and more predictable. In terms of activity, I've noticed that there were a number of important cases that were dealt with during the year. And in terms of respect, I think it's everybody's knowledge that the ACMU is very highly regarded as a rather efficient and good example of a government agency. Now let me go to the international experience on a number of points. Some of them will mirror what the chairman just said. The first one, maybe the most important one, is that in order to have a competitive environment that will be consistent, where individual incentives will be consistent with social welfare, one needs to have a number of complementary laws applying. Competition law is a very crucial one. It's an absolute necessity, but it is not able by itself only to bring about competition on markets. One needs to have an open trade policy, for example, because foreign competition, foreign trade brings competition to the country, as well as bring opportunities for the firms of the country. One needs to have regulatory reforms. There are a lot in any country. There are lots of past regulation that could be improved in the sense that their goal could be achieved probably with fewer anti-competitive means. So the object of regulatory reform is to try to streamline the laws, not to change their objectives, but to streamline them in a way which will make them as little intrusive as possible. The fight against corruption. Corruption is a deviance, a deviation from what would be a normal competitive process. So this is also a complement, a useful complement, necessary complement. Consumer protection. In any competitive system, the consumers play a big part because they are the ones who are able to direct their attention to the firms which are best performing. But for this, they need to trust the firms, and therefore there's got to be a framework to ensure that consumers are protected against the firms. A respect for the rule of law, etc., etc. And finally, I would add a competitive neutrality framework. I will come back to that in a minute. So competition policy is the set of complementary laws that all move in the direction of a better competition system. At the center of it, there's competition law enforcement, which is one part of what the agency does. The other part is advocacy, try to push governments and the legislator in trying to improve the laws. But I really want to emphasize the fact that the successes that we've seen in the world are countries where there was a real complementarity between different sets of laws towards a better functioning of the competitive economy. Second point is that economies in transition, like Ukraine, have specific challenges which are different from the challenges that exist in some other countries. One of the major challenges, of course, is to have a system of law, a system of business law, including bankruptcy law, including property law, including contract law, that will support a competitive environment and that will help transactions and therefore make those transactions more secure. Why? Well, because in many countries which are in transition, they didn't used to have such a set of laws because we were in a different system before, and there is a need to upgrade those laws in order to make them work well in a competitive market environment. We may have also specific problems associated with the presence of state-owned enterprises, some of them being less efficient than they could be, possibly. And there are several sets of issues there. One of them, which is really important, is that once one gets into a market economy, state-owned enterprises should be treated as private enterprises. And that requires sometimes something which goes beyond competition law, which we call a competitive neutrality framework, to make sure that in terms of access to financing, access to government, access to the justice system, all the competitors are treated the same way. There are examples of this. Certainly the state aid provisions in the EU are an attempt to precisely make sure that some either state-owned enterprises or enterprises which are close to the government do not get undue benefits compared to their competitors. But if we go to other countries, like Australia, for example, it has a very developed competitive neutrality framework. So that's very useful. There are other challenges in transition economy. The small size of the private sector, for example, is one. The fact that the financial sector is not so developed, there is not an enormous amount of money for new initiatives, new entrants, and so on and so forth. So again, one has to work on this. But there are 2 points which I think are even more important. One of them is that consumers have to be educated. Consumers are at the heart of what makes competition work. They are the ones. And by consumers, I don't only mean final consumers. I also mean consumers as firms. If they don't make competition work, competition will not work. We have experience, even in developed economies, in the financial sector, for example, or in the banking sector, where it's very difficult to get competition because it's too complicated for consumers to compare banking conditions, and they don't do it. As a result of which, and Bill Kovacic, who is on the board of the CMA, I mean, certainly the UK competition authorities have been very aware of the fact that one has to go even beyond competition law to try to convince or give the tools to consumers to make competition work. And I think that in countries that didn't used to have a market economy, maybe there's not a strong culture among consumers of making competition work. So that is necessary. Finally, there's a need to understand that competition is a dynamic process where there are winners and losers. There are people who don't do as well in competition, and there are other firms who do very well. Okay. So the issue is how, and this is going to be my next point, how the people who lose out in competition are treated so that we have a system which is acceptable. But it's a more dynamic system, maybe, than some central and command economies of the past, and one has to get used to the fact and to acknowledge the fact that it is dynamic and that therefore we have to think about how we are going to help the transitions. So my next question is, how can we have a dynamic system of competition which is inclusive, which doesn't leave people out of the benefits of competition, given that we have winners and losers? And there I would say that there are two major tendencies. One of them is to say, well, why don't we exempt from competition a number of firms, small and medium-sized firms, or, I don't know, state-owned enterprises, and so on and so forth. The problem is that the list is infinite of people who think that they deserve an exemption from competition law. The second one, which I think is a much more dynamic and much more a way to proceed, which is much more consistent with the desire to promote competition, is to facilitate the reallocation of resources for people who are faced with a disruption or with a difficulty because of competition. What competition does is, thanks to the consumers who reward the good performers, is to weed out the best performers and those who perform less well. What economic theory tells us is that the people who do less well in one activity usually, in the end, leave this activity to do something else. Now, this is called the reallocation of resources, something else for which they will be better able to perform. This is a very useful mechanism because it directs the resources towards their best possible use, but it has to be helped in real life. It does not happen as it does in economic theory textbook, where it happens by magic. Reallocation of resources means acquiring new skills. It means sometimes changing location. It means changing activity. It means a dynamic movement. And this is where governments, I think, by adopting a wise, interesting, and pro-competitive industrial policy, can help the transition. It's not a question. Education is a very good thing. Developing infrastructure, developing mobility, the digitalization of the economy, etc., etc. I mean, there are a number of horizontal policies that can be put into action to help the reallocation. And what that means is that the people who are going to lose out in competition are not going to be afraid of losing out, because they are going to be able to gather other opportunities for which they are better suited. This has been a bit neglected in the past, but it's clearly an important consideration, and certainly a much better way to go about promoting economic efficiency than exemption. My next point, which is the next to last point, is that to promote those changes, one needs an institution which in most countries has dual function. One very important function is enforcement of competition law. This is a quasi-judicial activity where the competition authority makes decisions. These decisions are reviewed by review courts, and this is part of the justice system. Now, this has one implication, which is that institutionally, the competition authority should be in fact treated as a judge with independence, trustworthiness, and the ability to discharge its duty, rather than being seen as a purely administrative body, because it's a body, but it makes decisions, and those decisions are legal decisions. The second part, of course, is that the competition authority also has an advocacy role, because as being a specialist in competition, it is able to advise. For example, I talked about the regulatory reform, to advise the government, for example, on regulatory reform. So to have a strong, stable, independent institution on the one side, and on the other side, on the part of the institution, to also have to gain the trust of people by emphasizing procedural fairness and having very strict guarantees for the people who might get into trouble from the competition law point of view. I think the building of this institutional framework takes a little time, but it is crucially important to the success of the project. My very last point is public procurement, and why it is that in many countries, public procurement are crucial, particularly in the first phases of the development of competition law. And they're crucial, first of all, because governments buy a lot of things, so there are a lot of markets there. And typically on public procurement, what governments do, they select a small number of bidders. So there's a restriction in the number of people who are allowed to bid, and that allows them more easily, if they don't want to compete, to try to get into some kind of arrangement which is going to be anti-competitive. So the financial importance of public procurement makes it worthwhile to look at. Second, there is the fact that unlike on other markets, very often on public procurement markets, you have a written trace of what has taken place. You have bids, for example, that can be examined, analyzed, and where patterns which are patterns not compatible with competition can be observed. And in fact, what we've seen in many countries recently is the development of algorithms that help the competition authority recognize patterns which are abnormal, and therefore focus on possibly problematic public procurement, because of course the competition authority should not look at all the public procurement, all the bids of all the cases. That would be too much. But there's a relatively easy way to detect patterns which are not compatible with competition. Finally, lastly, of course, I was talking earlier on about the relationship between different sets of laws and different sets of action that promote competition. Public procurement is one where there's a natural combination between the fight against corruption and the fight for more competition. And I have observed that in the cases that the ACMU has been dealing with, there have already been cases where there was some kind of cooperation between the anti-corruption body and the competition authority. We have the same experience in many countries. Brazil is one of them. You know that there are major corruption scandals in Brazil, but the CAGE, the Competition Authority of Brazil, has been hugely important in bringing to the fore, from the competition side, some of those problematic issues, which were public procurement, and in popularizing in Brazil the cause of competition. So I think it's very important to keep this as one of the focuses of a competition authority. Thank you very much.
Уваги ці речі. Дякую.
Speech.
Вступну промову. Dear colleagues, in fact, what has just been said by Jenny probably is the best overview of our executive summary of this forum, because first, this forum has a unique nature. That's because it is being implemented with the partial support of OECD, because the second panel, which will start at 11:30, is actually directly related to OECD work standards and priorities, and there we'll talk about potential gains for Ukraine from the cooperation with such organization, because the major direction of cooperation with the OECD is through borrowing of the best standards and practices, a formulation of the proper policy, the standards of legislation, the way they should be set in a country. So at this second panel will have separate module devoted to the impact of certain legal acts over the competition. We'll talk about the fight against corruption and a number of other standards related to economic policy as supported by OECD. The third module of this forum will deal with the experience of reform implementation during the last 4 years. And here we'll talk about the issues of reforming major sectors of economy, and also last night I received confirmation from Maxim Nefedov as Deputy Minister of Economy that he would participate in the work of that panel. Maxim Nefedov, of course, is a famous person who deals directly and with the public procurement, and will be able to hear his direct answers to the questions which are of our concern. What Jenny said about the reallocation or efficiency reallocation, maybe retraining of the employees of the staff, matters of how you can assist those players who need to change in order to remain competitive. All these issues have a lot to do with the policy of state aid. And our last session, session number 5, will deal with the matters of state aid, because the state aid actually is not a new bureaucratic terrible process intended to create some obstacles for allocation of public funds in support of certain economic objectives. The state aid is a kind of a new philosophy. It's not a matter of restriction, it's rather about more appropriate allocation of the public resources to solve some high priority or national priority issue. So all these matters tackled with Jenny in his presentation to bigger or smaller extent will continue being discussed within this forum. Now I'd like to ask a question to Bill Kovacic, who is well familiar with the problems existed in Ukraine, who participated in preparation of the previous expert reviews of the competitive field in Ukraine, who is absolutely well known and recognized international authority in this field. In addition, he is globally a recognized professor for competitive law. I will remind you, he used to be the head of Federal Trade Commission of the United States, and now he is the chair of the Consumer Market Authority in the UK. So my question to Mr. Kovacic would be as follows. As they say, if you want to eat an elephant, how can you do that? You eat elephant piece by piece. That's it. So your success in any business certainly requires a good focus on certain priorities and proper execution. So if we discuss building up an efficient system of protection of competition and implementation of the relevant policy, what our priorities should be and how we can execute that.
Yuri, thank you for the opportunity to participate in the program. I do want to talk about exactly the question you posed, which is how does an agency decide what to do? I think one of the most promising developments in the relaunch of the AMCU in the last few years has been the development of a much more effective internal process to ensure that the resources of the institution are focused in ways that generate the most benefits. This has become an increasing focus of attention for agencies around the world. It's the experience with 100 new systems in the past 30 years, the makeover of older systems. And my perspective is based on my experience when I was a junior case handler at the U.S. Federal Trade Commission 40 years ago, which undertook a major reorganization and refocusing of its program. My experience at the Competition and Markets Authority, which underwent a major merger to combine two predecessor organizations, and watching the work that Yuri and his colleagues have done. And I think a larger lesson that comes from this experience is that the quality of the program depends heavily on having good internal processes for deciding what to do and how to do it. As Yuri suggested in his first comments, there are 5 things that an agency has to do well. It's got to define its goals. What purposes do we want to achieve? It has to choose a strategy for carrying out those goals. And Yuri mentioned the AMCU with the World Bank is in the process of preparing that new strategic perspective. It has to choose priority areas that will support the accomplishment of the strategy. It's got to pick individual projects that will carry out the priorities in the strategy. And then it needs a process for looking back and asking, how is it working? These are the 5 critical tasks of management and oversight that separate a good agency from an ineffective agency. I want to emphasize how much I think progress has been made on the key related questions of setting priorities and choosing projects. One of the most promising developments, I believe, for the AMCU has been to establish a more rigorous mechanism for deciding whether or not to give a green light to specific projects. And there are basically 7 things that go into deciding what projects to pick. The first is to ask in a clear way, what do we expect to get from this project if it works? Are we going to improve economic performance? Are we going to achieve a good result in shaping doctrine? Are we going to give our staff valuable experience in developing specific cases? So the first thing is to have a clear idea of what we hope to get if it works. Second, what are the risks? How much is it going to cost? What happens if we lose? What kind of political opposition will we face? The fact that there are risks is not a reason to stand back, but a clear understanding of the risks is essential to deciding which battles to fight and how many to fight at one time. A third critical question is who's going to do the project? I think there is a tendency in a number of agencies to assume that your best team will do all of your projects. And when you add a new project, it's the best team. In every agency, there is basically a fraction that you can identify. The denominator consists of all employees in the agency. The numerator consists of good employees, people who know what they're doing, who have real skills. The numerator and the denominator in most agencies are not the same. The first on top is smaller than the second. And one of the hardest things for an agency is to bring that top number closer to the bottom number. And if you take account of how good your team is collectively, that tells you how many projects to do. It tells you what you can accomplish. And you can't launch projects that you can't deliver because the team is too weak to do the job. Fourth, basically, how long is this project going to take? What will it cost us to carry out the project? And very important, how does it fit in the whole portfolio of what we have to do? We have existing commitments. You can't look at projects in isolation, because if you look at them in isolation, you don't take account of how good your resources are to carry out the projects. You're not doing an accurate assessment of total benefits, of risks that you face. And then last, to have an idea of how to answer the question, how do we know that it worked? What are going to be the measures of success in the project? A crucial mechanism for doing that is to have an internal process, an evaluation or screening committee that decides whether to give a green light to the project, to decide what to do. That committee establishes crucial discipline for the entire organization. It helps determine what the whole program should look like, and it helps decide in key instances how specific new projects fit in the entire picture of what the agency's doing. I think a very positive sign for the AMCU in the last few years is those structures are being built. Good technique, I am convinced, produces better results over time. It is not a guarantee of good results. At one point in my life, I worked for several years for newspapers. I thought I was going to be a journalist until I discovered the glory of competition law. But as a journalist, I interviewed lots of athletes and asked them, why do you train? Why do you practice? And a core answer I got from successful athletes is that by working on my technique, I increase the chance of success. I can't guarantee success, but I know if I do things the right way, I am more likely, more often, to get a good result. And I think those good habits are being developed here. Let me finish by applying it to the example of procurement, which Fred mentioned before. What might we gain from focusing on public procurement matters? Better economic performance, a means of showing to the citizens that they can trust their government. I don't know many things that are more disheartening to individual citizens than seeing the money they pay in taxes stolen, wasted, squandered. That dissolves the trust that is essential between citizens and their government. If you're taking my money and throwing it away, why should I trust you to do other things that are crucial to the well-being of society? And if you're interested in inequality, it is in procurement that governments deliver so many benefits to the dispossessed. So if we do procurement projects well, there is a tremendous possibility of offering good results to society. What are the risks? Often the beneficiaries of a corrupt or distorted process are politically powerful. They don't sit back and say, thank you for correcting the process. They fight back. And collectively, they can fight back with a lot of power. And if you take on corruption, they will fight back even more vehemently. So one has to think about how to deal with that response that inevitably will come in the system. These are not easy projects to do. Who's going to do it? Do we have the right team to do it? How long will it take? How much money do we have to spend? And very important, how many fights can we take on at one time? Are we going to fight all the battles? A few battles, some big ones, some small ones? There's no good answer to that. But the wrong answer is to say, just add another one, another one, another one. without asking what the effect on the entire program is. And last, how do we know it worked? Is the government getting better results? Do you see better citizen satisfaction, better services, more hospitals, more schools, more uniforms, more meals for children, better results because of the program? Again, not scientifically precise answers, but going about the process in the right way, I think, points you in the right direction. Something very promising about what's happening in the country is that the institution is working hard on doing these things. That is a promising sign for the future. Thanks.
Bill, thanks a lot. Дуже дякую.
Thank you so much.
Насправді,
Well, in fact,
пан Kovacic,
Mr. Kovacic mentioned rather important topics which are connected with
як саме
how
публічна установа,
the public institution, which has the competition institution, has to be efficient.
оцінка ефективності
Because the assessment of the efficiency
публічного сектору
of the whole public sector is a very
дуже важкий,
hard and complicated exercise,
оскільки зазвичай
as mostly
того, щоб оцінити
to assess the efficiency, first of all, we need to assess and to define what's the end product,
кінцевого
which is focused upon the end so-called consumer.
робота, які продукти
Which products, which goods are produced
установа
by the correspondent institution and for the sake of the satisfaction of whose interests.
саме. Це задоволення випадку.
This satisfaction in the case of the competition agency.
Різні країни мають різні відповіді.
Well, on this question, different countries have different answers, and I must say that.
Подібні питання
The similar questions connected
як повинна бути
with how should the whole competition agency be constructed, how we should organize the internal processes, how
можна відбивати
we can
великий шквал, великий потік
try to
маленьких дратівників, скажімо так,
not to pay attention to the big, to the small manipulation signals, small irritators,
які можуть мати на меті
which can aim us to
відомства не вирішувати
not to solve
системні проблеми
big systematic problems of the state, but in fact they want to substitute the court in the solution of the bilateral conflicts of the smaller subjects. All of those issues, in fact, are not unique for Ukraine, as we can see. What the efficiency of an institution is, undoubtedly, the efficiency of the system of the public administration and of the whole state as a system is that each institution must perform its obligations with high quality. When the competition agency begins to perform the functions of other organizations because of the tools of the law protection are not developed enough, or the legislation is not improved enough, or the subjects and participants, the consumers, are not aware how they can protect their rights in a proper way, we can face the situation when, for a long time, we saw at the committee, when we were created in the beginning of the 90s, when in fact we didn't have any branch regulators, and there was the very substantial weight of regulated markets, which were traditionally the main priorities of the institution's activities. And now we can see, well, I will present a bit later the report of Anti-Monopoly Committee for the 2017, so we can see some positive dynamics. That yes, we have the growth of the applications and complaints. People go on complaining towards the Anti-Monopoly Committee, and maybe this is a good sign. This is the good symptom that they have trust towards the institution as an organization which can solve the issues of the people. But when we see that with the number of those signals and complaints, approximately 30 to 40%, we automatically have to transfer into different institutions to process them properly in an appropriate way. There is the question why people don't apply to those institutions at once. Still, according to the results of the year, we can see almost 2,500 of violations of crime which have been stopped. This is, on the one hand, is nice, but if we look, on the other hand, to such countries as France is, or other developed countries who are the EU members, the number of the cases in those countries will vary from 20 to 100, not more, but not 2,500 or 3,000. Undoubtedly, part of the issues which were mentioned by Mr. Kovacic are the subject of the law drafts which are already in the Parliament now, and one of these law drafts is the law draft of Mr. Ivanchuk, which directly allows the committee to refuse to open the case as for the criteria of the low significance of the certain abuse. All of that is really nice, and again, there are better standards which we can already copy down from other countries, but the world is not staying at the same place. As in a very well-known fairy tale, we need to run to stand at the same place, and we need to develop to run even quicker. So the next question is for Mr. Šarūnas. Now, there are lots of initiatives, both at the level of the European Union, to systematize the standards of quality, the standards of activities of competition agencies. There is certain experience which Lithuania came through in the construction of an efficient institution and agency. You needed to overcome all the same problems, the similar problems we are fighting now, both as for the construction of your own reputation and for those competences which are foreseen by the law to formulate them in the high-quality processes. Though you can see the abstract nature of this writing in the law, you've developed certain written or maybe non-written algorithms how to select the high quality, the best cases to be the respectful player, both in the Lithuanian Republic and at the European level. So, Mr. Šarūnas, I'd like to hear your experience, the experience of the construction of the efficient competition agency in Lithuania.
Thank you, Yuri. I like the range and the depth of your questions. How many minutes do I have? 2 or 3? Or 10. Which reminds me, by the way, I'll just take a step back. Yesterday we had a dinner. Well, you would say, so what? Everyone had dinner. That was not just any dinner. We have our host speaking, Yuri. Well, again, if you have a dinner, hosts normally speak. So what's special about that? Yuri said that his speech will be quite ordinary. It wasn't. I will not get into emotions of the speech and so on. We were not crying. We were close. But I think the message was, we will not let you experts out until we squeeze you dry. And I like the message. You see quite a lot of experts sitting around here, and at the MCU on the 7th floor, where we are located, we rub shoulders with the Americans, with the OECD people, there's also UNCTAD coming from time to time, EBRD projects, and so on and so forth. What are we all doing there? Well, we're all working on the question, or the questions that you raised, how to make a competition authority more efficient. Because if you're more efficient, you can do a better job in serving the interests of consumers. That's easy and that's fairly abstract. What I can say that, well, being efficient, it's not something that you reach and you're done. It's a moving target. So when we come here as experts, we are as much learning from you as you are learning and getting from us. There is no question about that. My colleagues sitting in the back there can confirm that. We are learning every day. And when it comes to efficient agencies and efficient competition policy, I think one thing, and Fred and Bill have already mentioned that, but I want to bring it back. One thing that is very important is competition policy is too important to be left to competition authorities. If we imagine, or if politicians imagine that, well, here is your law, go out and apply it, that's a recipe for disaster. I myself have seen competition authorities with very bright people that have completely no political support. They are operating in a vacuum. The things they're doing remind some sort of intellectual games. It's interesting to play them, but what's the effect on the society? So the first thing is competition authorities cannot be left alone. They cannot operate efficiently. They cannot have any effect on consumers, on the economy, if they don't have support of politicians, first of all. So the role for politicians in making competition authority more efficient, more effective, is engage in the process. This thing that competition authorities are doing will have effect on your electorate. It is important. The other thing is, don't micromanage the authorities. Ensure they are funded, ensure they have adequate tools, demand responsibility, but don't interfere into individual investigations. That's because, micromanaging, telling the authorities what they are supposed to do, what companies they have to investigate, that's not how the efficient competition authorities work. Actually, it will have the opposite effect on the authorities. Professionals, they don't like to be told how to do things. If you go to a restaurant, you don't say, a chef, well, this recipe can be done a bit better. You have to demand responsibility from competition authorities, and we always expect that because it's important to have feedback. But we want to have freedom of maneuver, because that's the way to be efficient. When I talk about competition authorities' role in enforcing competition policy, another thing that comes to my mind, and that's not a new phenomenon, but it's been coming back. And I'm looking at Fred because that's something that Fred was elaborating on a week ago in Copenhagen. It's the issue of fairness. Fairness, the idea of fairness, of fair markets, fair competition, fair outcomes, fair processes coming back. And if we want to ask ourselves, how do we operate as an efficient competition authority? It's difficult to avoid nowadays the question about fairness. How do we address this issue? Because that's what people expect from us. Well, not necessarily from us as in competition authorities, but from the government, from the parliament, from politicians generally, from state authorities, from the economy, from business. They expect fairness, however difficult it may be to define, but it's a big thing. So if our decisions somehow seem unfair, well, it doesn't matter that we improve efficiency in the economy. If people feel detached from it, if people don't get benefits of a better of economy, then we as a system, we're losing. I don't know, Fred, your speech last week in Copenhagen still keeps me awake at night, to be honest, and I don't know the answers to that. Not yet, not yet. I hope that's coming. I'm still a bit old-fashioned, probably, in this sense, because the question is, do we, as competition authorities, are we as competition authorities well equipped to deal with issues of fairness, which for me is balancing many values. Many values that are difficult to compare. Like on the one hand, efficient competition, consumer welfare. On the other hand, employment, environment issues. Any other values that may come up for you as a competition authority, for example, in assessing a merger. Do you allow this merger of two supermarkets if you know that's going to affect negatively employment in some region? What do you do? Are we well equipped to sort out these things? Me personally, I have doubts. Legally speaking, are we allowed to take decisions that are essentially political decisions? Again, we're not a political agency. We're not elected officials. We're appointed. We are professionals. We're trying to do our best. Can we be asked and expected to issue decisions that are fair, provide good balance of different values? Again, it's complicated. So maybe further on in the discussion we can come back to that, but it's something that we're facing right now as competition authorities, and that's a big part of how to be efficient. One other thing that I wanted to mention, it's the role of experts in the case of the Ukrainian Competition Authority. As I mentioned before, we have quite a few of those. At the MCU right now, working on draft laws, draft guidances, on improving procedures within the authority. All that is fine, but at the end of the day, you cannot outsource your competition policy or your enforcement to the experts. You must take the best out of them, squeeze them dry, but then you'll have to do it yourself. That's what we experienced as a developing authority some years ago. That's what the authority in Ukraine experiences right now when it rediscovers itself, relaunches itself. And that's not going to be easy. With so many experts around, so many ideas, so many different experiences. But as Yuri said, we'll have to find our own way. No one will come and will just put you a finished product on the plate, and no one will tell you, well, now this is it, you can eat it, it's great. No, you'll have it. You'll have to cook it yourself. And as an authority, it's good to learn from the mistakes that those experts that visit you made in the past. Because a smart person learns from the mistakes from others. Only fools, like us, like me, we, to a large extent, we learn from mistakes of that we made ourselves. I'm looking to my American colleagues. I'm not saying, Bill, that there's anything foolish about the US, but US was the first country, one of the first countries to introduce competition policy, so you had to learn from your own mistakes. And I think you can confirm you made quite a few.
I realize that the day may come when I make a mistake, and I know it will be very disappointing when it happens, but it hasn't happened yet.
So that's an experience of more than 100 years speaking to you. learn as much as you can from the mistakes that we made in the past, and invest in the future. That's what we are trying to do in the authority in Lithuania, to play a long game, not going to after like results that can be easily achieved. Ongoing cases, that's important, I know. Society expects from us enforcement decisions, politicians expect from us the same, but we have to build an authority long term. But if we don't do that, then we will be building a building without without strong foundations. And I think that's my last point, but I'll be happy to elaborate further on that.
Thank you,
Thank you very much.
Дуже дякую, Шару.
Take over now from Yuri. I think perhaps it's worthwhile recalling that the main theme this morning is to address the inclusiveness of competition policy, and perhaps worth reiterating what also Yuri said earlier, that we have a common understanding of what we understand by inclusiveness. And I perhaps here draw on what United Nations Millennium Development Goals and later Sustainable Development Goals to define inclusiveness as creating prosperity for all, meaning prosperity for business and prosperity for consumers. It also means not leaving anybody behind, avoid marginalization in this process. And I think here, this is where the challenge facing not only competition authority, but overall policymakers, how to achieve this inclusiveness in the process. Perhaps, we've heard in the first part some of the best practices and in the OECD, in the United States, and also now from Šarūnas. And I think this second part will need to focus more on experiences from other agencies which have relatively recently introduced competition law and policies. And the question we will ask ourselves is whether there are some best lessons learning, as Šarūnas just says, from other people's mistakes. But I will add perhaps to best relevant experiences, because some of the best practices might need to be taken into a context within which the country is considering those policies. And perhaps here just to emphasize that the context of Ukraine is special. Why is it special? Because both the country, the modernization of Ukraine is work in progress, but the competition authority and the regime is also work in progress. It has progressed a lot, and therefore the role that the Anti-Monopoly Committee plays, it is dual, in the sense that it's two-pronged. It's working on reforming its own institution and providing the powers and the efficiencies that Bill and Fred and others referred to, but at the same time is involved in reforming the government policy and the other laws that are taking place. And this raises the question of how to phase these reforms. Which should come first, which should be second, in what order. And I think also what's mentioned earlier is perhaps here identifying those areas where maybe marginal reforms can lead to very important benefit. And this is a challenge again, because the question of fairness and the question of inclusiveness is at the heart of these reforms, because we know that the costs are immediate right now, but the benefits are long-term, and they are not necessarily equally distributed. And the challenge, of course, for the competition authority is to how to manage this. As Yuri just said, we need to run just to stand still in order to maintain this process. So these, I think, are some of the difficulties that Ukraine Anti-Monopoly Committee face today, working within overall reforms and modernizing the economy, and at the same time modernize its institutions and being able to catch up and moderating the immediate cost while generating long-term benefit. And here the challenge clearly immediately is that perhaps the most difficult part is managing expectations. Expectations of consumers who want the government to intervene in price control because there are, legacies of the past of state-owned monopolies, how to get these reforms, whether electricity and energy prices, and we will hear later from United States Federal Trade Commission some of these practices that could be useful here. So how to manage the call for intervention, for price control, or regulations, for support for SMEs, for opening new sectors, or providing or really allocating of resources that I think Fred mentioned here, so as to ensure that there is coherence between industrial policy and competition in general through this umbrella, which I think you mentioned is under work. So perhaps what we need to do now is to listen to more experiences from other countries. And the next is Boris Gregor, Vice Chairman of the Slovak Republic, and share with us perhaps some of the experiences and ideally some relevant that could be useful for Ukraine. Thank you.
Thank you. Okay, it's working. I'm very pleased to be here today and to have the opportunity to share our experience in the field of competition protection and state aid coordination with all of you. As the Vice Chairman of the Slovak Anti-Monopoly Office, I'm responsible for so-called first instance of administrative proceedings and for investigative activities carried out by organizational departments of our authority. Our focus is on cartels, vertical agreements, and abuses of dominant position and merger and acquisition control. The circumstances and conditions we are working under are changing turbulently. For 2017, we set several main tasks in the area of competition protection and state coordination. I would like to open my contribution to this forum discussing the area of competition. Our goals and intentions remain also for this year. So we have to enforce competition law both in its national and international dimension, including the application of the regularly reviewed prioritization policy, to contribute actively to development of legislative framework of competition protection in Slovakia in coordination with the competent European institutions. As Mr. Jenny mentioned, the important thing is the consistency of law framework, and I think we have big room, or we have the obligation to coordinate our activities with regulators, especially in regulated sectors where utility companies operate their business, or financial or insurance sectors. This is the main task what we are going to do this year, to open discussions about these problems, because the consistency, as we found out, is not as we want. The next task is to raise awareness of competition law and the economic and social consequences of its infringement, and intensify communication with representatives of association impacted. To develop the cooperation with other central state administration bodies in creating an effective system of detecting and correct sanctioning for competition law infringements and business environment that stimulates competition. To initiate and develop cooperation with renowned Slovak universities and institutions focusing on the legal and economic aspects of competition protection. We set some priorities for these years, and these priority sectors we are going to concentrate our attention is e-commerce and online trading, then agriculture and food industry, and I have to say at this moment that this agriculture and food industry was very impacted by subsidies and subvention schemes and financial mechanisms in Slovakia, and we see some structural changes which are undesirable. For instance, crop farming is more preferred than animal farming, and these changes are, I think, not good for developing this sector, and we have to open some inquiries and some investigation how to help implement new rules for supporting this sector. Then information systems and information technologies, sectors affected by state regulations, as I mentioned, utility companies, financial and insurance services, etc. We opened inquiries in these sectors in 2017 and to thoroughly map the affected markets to the level of competition therein, as well as factors with the potential to influence the current state or future developments here. In terms of practices, the office continues to focus on cartel agreements, bid rigging in public procurement and non-notified mergers. The office also involved in programming, implementation, monitoring and evaluation of the European structural and investment funds. In 2017, we started to fundamentally revise the risk indicators under the European structural and investment funds management system and establish a flexible model of cooperation with the central coordinating body, with the aim to regularly update the evaluation toolbox for subjects that are involved in the control of the funds of these financial mechanisms. That's the only way how to effectively face the skyrocketing number of received complaints in this field. The number of received complaints increased 5 times in last 2 years in our competition authority, and this workload is a challenge for us, and we do have to better explain how to control, how to detect some suspicious facts in public procurement documents. This is the only way how to handle with it, because it causes huge problems for our competition authority to handle with this such a huge number of complaints and conducted investigations. Within investigative and decision-making activities in relieving agreements restricting competition, the office amended its concept of informant, whereby a natural person who is not undertaking pursuant to the Act of Protection of Competition or an employee of an undertaking already participating in leniency program has the right to remuneration for providing the office with substantial information or evidence if she or he meets the conditions stipulated by the Act. We introduced some significant changes in the way how our authority protects informants' identity. We also created internal and interdivision working groups to set the prerequisites for updating selected soft law and guidance of the office, setting out the details of exercise of its competencies in relevant areas. Besides defining rules, the office will also focus on application of investigative tools stemming from the provisions of the Act on Protection of Competition. Regarding the necessity for raising awareness of competition law and competition advocacy, the office intensified its communication mainly with associations and of undertakings in Slovakia with the aim to raise the awareness of representatives of these interest groups and representatives of their members through participation in events organized by the office or themselves. initiate cooperation in creation and maintenance of the competitive environment in various sectors, mainly through active cooperation in legislative process. I think that I should mention also the cooperation with Slovak universities. Last year we intensified our cooperation with University of Economics in Bratislava via the agreements on cooperation with its selected faculties. Cooperation will take place in following areas: scientific research and advisory activities, socially beneficial activities, learning process. Within the fundamental area of mutual cooperation in scientific research and advisory work, the relevant parties to the agreements will focus on sectoral and market analysis, as well as impact and case analysis and studies. In order to prepare sectoral and market analysis and studies necessary for the activity of the office, the cooperation within the scientific research activity will include the processing and evaluation of publicly available data by mutually agreed methodology into predefined structured documents and their regular updating, as well as defining and mapping mutually competing products, substitutes and complementary products and services. Mutual cooperation with faculties within ex post evaluation of the office's decision-making activities will include formulation of impact analysis and studies through the processing and evaluation of publicly available data and data collected through targeted surveys and the formulation and verification of hypotheses in the area of impact on individual sectors, markets, and on competition. I would like to mention something about area of state aid and about main tasks set in this area. As part of intensified cooperation with existing aid providers in the upcoming years, the office plans to continue organizing working meetings with aid providers focused on consultation on state aid or on specific problems related to application of state aid rules in practice, organizing training sessions for providers of state aid and the de minimis aid, cooperating with the government offices of Slovak Republic in education of administrative capacities in the area of state aid, informing and aid providers on results of monitoring of state aid schemes by European Commission. The office continued developing cooperation with partner institutions in other EU countries in the area of state aid. I would like to thank you for your attention, and that's my last note.
Thank you. Thank you very much. Without doing injustice to what you said, I keep in two major points. One is emphasizing cooperation. Cooperation with other agencies, and in particular the yearly priority sectors which are affected by government legislation, targeting also advocacy to other partners, working with universities as such. And then in addition to this, I think you also mentioned that internally the agency has continued to adopt its own rules and legislations, procedures for protecting informant, way of detecting bid riggings, managing the large number of complaints that are moving forwards. And I think those shows clearly that cooperation with other agencies and other sector regulators and targeting those in priority sectors fit very much what the previous experts have said, and continuing to advocate internally as well and improve the process in order to adapt the legislation to meet the challenges. Now, let me give the floor to Mr. Kasilis from Latvia. And
thank you. So what's my presentation? Okay, so I can do it without PowerPoint. So I completely agree with previous speakers that no competition authority can work isolated. So I would say even more that cooperation with other public institutions is like a key factor for successful competition policy, because there are always a lot of issues which can be solved only in a complex manner, and the competition authority as alone cannot solve that issues. Therefore, you need like help from other public institutions. So today I will share some practical examples of cooperation between our competition authority and like anti-corruption agency, public procurement bureau, and also with higher education institutions. So already for many years we have recognized a problem regarding public procurement procedures in Latvia. So there are a lot of indications of prohibited agreements, and so we decided that we should make like a complex advocacy procedure regarding that issue, and invited also to join to our activities also anti-corruption agency and public procurement bureau. So we have organized like common events all around the country in the major cities of Latvia, and our target audience was entrepreneurs, as they are participants in the public tender, and also municipalities, as they are procurement organizers. So each of institutions have like different competencies. So we are covering topic regarding what are cartels, what's allowed, what is not allowed. So we also have a special topic to the municipalities, how to recognize indications of cartels during procurement procedure. So anti-corruption agency is explaining what is a conflict of interest, what is a responsibility of officials, and public procurement bureau is more focused to tell municipalities how to create efficient procurement procedure and what are the rights of entrepreneurs during the procurement procedure. So I would say that this example of cooperation is very efficient, as instead of 3 different events, like entrepreneurs have to come to just one event where they can get answers to all questions related to public procurement. And also there is another benefit from such cooperation, is especially for our authority, because anti-corruption agency and public procurement bureau, they are important source of information regarding cartels. We have received like a lot of information about potential cartels from those institutions. So I would say this is also our interest to educate and to work so close together with those institutions, because as they will be more efficient, more information about cartels we will receive from them. So just one example, I would mention that it's always important to receive and to collect feedback after each event, which we are doing. And so we are receiving feedback like about topicality, about content, about lecture, about question and answer sessions, and based on such feedback we already have made some amendments to the program and to become to improve quality of the seminars. And one other example of cooperation is with higher education institutions. So our partners are all leading universities in Latvia. Actually, there are 3 of them. And the main reason why we started that cooperation was already that some time ago we recognized that our authority had a problem to attract new experienced and professional employees because of salary. And then we decided that we have to change our focus, and now we are focusing more to last year students from universities as our potential employees. Also, such cooperation with universities help us to promote competition authority as an employer and promote our employer branding. And additional bonus, of course, is that it's education of society, as as those students are future employees in public sector and or entrepreneurs, so they will be more educated regarding competition issues. So in the main area of cooperation are guest lectures. We also have helped to develop some lecture course. We have agreements regarding internship with universities, so we have promised to deliver some certain amount of internship places for the universities, and I would like to mention that we are trying to use that possibility as efficient as possible, and we are trying to give to the students like meaningful tasks, so our authority can benefit also from those students. And other area of cooperation is, so we have sent recommended themes of diploma paper, and also we are providing assistance to the students if they are writing their diploma paper about competition issues. And this year we are also planning to launch like a competition about best diploma paper for the students who are which are writing about competition issues. So, and as a conclusion, I would say that it is extremely important to cooperate with other institutions, because then you can create synergy and work more efficient. And also you can learn from your partners, because they have other competencies as you, and you can also educate your partners. So it's a win-win situation. And what's also important thing is you have to be very focused on relationship management. As I have like more than 15 years experience working in a banking sector, and I know how important is relationship management if you want to establish long-term cooperation with your customers or business partners. And I would say here is the same situation. You have to understand what are your partner priorities, what are their goals, and you have to have regular communication and be ready for compromise. Okay, thank you.
Thank you very much, Mr. Lars Kasalis. As we heard, I think the Competition Council of Latvia also emphasized the need for cooperation. And I note with interest that the cooperation actually took the form, closer cooperation, particularly with the Anti-Corruption Commission. And it was very interesting to address the question, but as well as that question of fairness can be addressed under the theme of fighting corruption, because it creates, although the formulation of the seminar I saw was fair entrepreneurship, which means that leveling the playing field can be one way to address the issue of fairness, and competition authority can address this. I also note that cooperation, I think also with the universities, can be a very important element, both for promoting and using advocacy, but also recruiting, if I heard internship and new staff from this. One last point, which I thought was very important, that advocacy, you also mentioned the importance of assessing and searching feedback on what your advocacy has been like, and having this feedback on the activity can be very useful. Thank you very much. Now we turn to a very interesting presentation, which I think John Haig from the USAID and Federal Trade Commission, if I understood correctly, will be speaking on the experience of the United States in regulatory reform of the energy sector, and how this perhaps also might address the question that has been raised by the chairman this morning. You have the floor, John. Thank you.
Thank you very much. Before I get started, I need to do the usual excuse, which says that these are my personal views and not those of the Federal Trade Commission. And I also want to have a shout out to both the AMCU and USAID for allowing me to be here and having a great experience the last several months. I actually have a big, long set of slides, which I'm not going to show you, because this is basically talking about the U.S. experience, and you can access them online and understand basically how what I'm saying relates to what the U.S. experience has been. While it's often the case that an agency gets to sort of pick what it's going to work on. Sometimes something comes along which is so big that you really don't have much option. And electricity restructuring and re-regulation is one of those issues which is going to be coming down the pike for the AMCU, and it has been a problem and focus of attention at the Federal Trade Commission and at the U.S. Department of Justice since the mid-1990s. And I'd love to say that we'd reach some sort of resolution, but really the situation is that it's a moving target. Reforms which might have been really great reforms in the 90s are sort of fading in importance as technology changes. And so part of what I want to talk about today is the relationship between competition advocacy and cases and how the two of them can help country develop the restructuring reforms which you need to deal with changing technology. So why electricity? Well, first of all, electricity is a huge industry and it affects just about every other sector of the economy. So if things are great in the electricity sector, that's wonderful for everybody. If it's totally messed up, then a lot of other places are going to have a lot of difficulties. Second is that for many years, most electricity matters were dealt with as natural monopolies. That is that, well, of course it's going to be a monopoly. There's really not any opportunity for competition here. But technology has now arrived and has been coming along for several decades so that more and more sectors of what used to be a vertically integrated chain of monopolies doesn't make any sense anymore. And so that's a situation where competition agencies are compelled to help the process within their nation so that they can deal with these things successfully. And of course, in the case of electricity, there's also, besides innovation in terms of the technology, there's also innovation in terms of the externalities associated with the industry. And there's also a lot of interest on the part of consumers to directly participate and make their own decisions in how they deal with electricity. So I guess the setting for my few points will be, well, the U.S. has been doing this for quite a while, but we don't really feel like we've gotten to any end point. Rather, it's an ongoing process, and we're glad to share our experience and perceptions with the hope that the experience that Ukraine has won't be quite as bumpy as that of the United States. So I just want to basically set three themes. The first of all is that electricity restructuring and reform does have a big potential upside. I will just mention a few of the benefits which the U.S. has experienced. Benefits which basically have come to industrial customers, commercial customers, and residential customers. So the list is fairly long. I'll just say a couple things about a few of them. So efficiency. As a result of increased competition, our actual electricity generating plants operate more efficiently because people are worried about being available and producing power when the price is high. So it drives the sense of you ought to be there when the power is needed. Flexibility. Over time, at least in the U.S., we've experienced increasing peak demand relative to trough demand. As that gap increases, you have to have a system which can go up and down in response to changes in demand more readily. Innovation is clearly something which is started in the computer and telecommunications areas and now is coming into electricity. We have lots of areas in our country where people are investing in solar energy. They want to be able to monitor their use of electricity at any particular point. They want to be able to manage their power use so that their bills don't get so high. All those things are enabled by technologies which are coming along. And of course, the environmental part is an important one as well. So the first theme is there's a real opportunity for substantial gains which will occur to all your customers. The second point is it's not easy. It's a difficult, time-consuming task to make sure that the reforms that you implement are going to actually provide benefits and not result in huge costs. The state of California during 2000 experienced what we call the California energy crisis. It's a situation in which the market structure reforms that were implemented were bad. The estimate is that total damages were $40 billion, which is a lot of money even today. So the usefulness of making sure that your reform process is vetted in terms of international experience and makes sense to the experts is a really important caution. And the final point I want to make is that California today is yet going through another revolution. That revolution has to do with distributed generation. So one of the innovations is, solar panels on the top of your roof. And, this seems like a small deal to start with, but California is now experiencing something called the duck curve. And what the duck curve means is that output from the solar panels is so large that it is driving the wholesale price to negative levels. That is, the solar panels alone are producing more power than the whole economy is demanding during many hours. Right now, the estimate for California is that 15% of the hours will have negative wholesale prices. That means they're paying you to use electricity. Dealing with that situation and also then the need when the sun goes down to suddenly ramp up generation at a very rapid rate requires a very different set of assets than were there originally. And part of the benefit of having a competitive system is that you can accommodate that kind of changeover in the mix of generation which is required to deal with the new technologies which are coming along. If you look at some other states in the United States, they are still working with a system which says our generation plants are going to last for 100 years. There is no way in a situation in which technology is rapidly changing that that's a reasonable way to regulate anything. So that's why competition is essential, but you need to do it carefully.
Thank you very much. Without necessarily trying to summarize what John says, I think since he has a long series of slides, it's perhaps worthwhile going through them to know the detail. But what I keep from the speech is that setting priority for agencies and identifying sectors for reform might actually be exogenous, may be decided for you. It's not something that the agency can work on itself. And I think this is something that worth perhaps keeping in mind. The implication also for it is that technology in certain sectors like electricity can add another challenging dimension in the sense that agencies need to be flexible and adaptable in order to understand which direction the technology is moving. And I think the last example of so-called duck curve, where you have excess supply of electricity at more than 15%, if I understood correctly, of the demand, clearly this requires changes, because the aim of the reform is to make markets work effectively and poses new technologies for the firms and consumers to work out, and raises the question whether any regulation might be appropriate at all in the medium to long term. So perhaps this is add another complication to what we talk about reforms. And perhaps let me just stop here at the moment and maybe pass the floor to Yuri if we have any questions.
I'll speak Ukrainian. Тут що можна сказати, що
Thank you so much for the first panel, for all of the participants. During the first panel, as I've already said, we've mentioned the issues which are, on the one hand, are rather open and rather debatable. On the other hand, they are universal for everyone. This is both the efficiency of the institution, the appropriate standards which have to be developed beyond a creative part of the work, which must become the foundation for the work of the institution. There is the certain part of the work which is connected with the personal, I'd say, skills and expertise, with leadership, because just to make people to be proactive, to make them leave their comfort zone and to be in some political surface is sometimes not that pleasant. And some of the relationship with other participants of the political process can be rather unpleasant. So it claims a certain bravery. So in fact, when we speak about the task of not just to be promoting yourself, not to write some provocative things in the social networks, but to construct the system which will be long working, efficiently working, not to be separate from other authorities, but which will catalyze the issue of the system, it will undoubtedly, on the one hand, is a big piece of job. On the other hand, we need to look analytically at the precise things, at the precise task, which have to be implemented one after another. You don't agree with me? So, here, one of the priorities is what we are working at least now together with Mr. Šarūnas, is to make a detailed analysis of the standards of the competition law as it is formulated in the European Union, not only of the guidelines which had the EU at the highest level, but the really detailed bricks out of which consists an efficient law system of the protection of competition. And not just to define politically that we need to stop the abuse of monopoly state, but to analyze in details the system we are having now, and to define the events, the precise events we need to implement. This exercise, as says Šarūnas, it's rather interesting for him too, because European countries don't have the overall guidelines and material about that, so we are doing this exercise for the first time ever. But it's a very interesting project, which, in the end of the day, should really create, out of our legislation, the really correspondent and compatible to the best world practices and standards product. The question of investments into science in the cooperation with the educational institutions is what we have actively begun this year and went on with this work this year. We formed the Scientific Expert Council. We've signed the memorandum with the educational institutions. We are the first partner of the legal high school, of the new project of judicial practice on the practical training of the practicing lawyers. So I'm glad, really glad that an opportunity of the participants with the participants of the foreign countries and our international partners are helping us. We're using this opportunity for the training because, for instance, tomorrow Savin Zibelski will have a 2-hour lecture at the legal high school as for the issues of the modern competition law and the standards of the EU on the vertical agreements and virtual competition. You wanted to ask a question? Yes, please. Thank you so much. My name is Yaroslav Khachevich. Recently, I've been a scientist of Lviv Polytechnic Institute, so for 20 years I've been the teacher and wrote the thesis on the topic of adjustable system of the competitiveness of the industrial enterprises. I really deeply know the topic of competition and competitiveness at the level of the industrial enterprises, and when today we are looking at the issue of inclusiveness of the state policy, I've got several questions and suggestions to the state authority, like Anti-Monopoly Committee. In fact, we can create a very nice competitive environment for our company, and for the foreign companies, right? Lots of things are said about the fairness, about the integrity. Everything is nice, but if the state doesn't deal with the aspects of the development of all of the forms of competitions. But in the word anti-monopoly we have the word monopoly, but there can be oligopoly or any other kind of competition nobody deals with. The development of the competitive environment is really important, but there should be an authority which would deal with the aspects of the development of competitiveness, not only of the enterprises, but of the whole national economy. I think that the colleagues from the United States will not let me lie that in the US, besides the Anti-Monopoly Committee, there are certain state authorities which provide the competitiveness of their national enterprises. And as far as I know, we don't have anything like that. So, what do you think? That we shouldn't be just the ground of the competition for the Western companies, but we should develop the competitiveness of our national economy beyond the borders of our country. Thank you. Let me begin, and maybe someone of the participants and guests experts can comment upon your words. Look, in fact, out of the comment, out of the question you asked, I began with that. In fact, my speech was begun with that. When we opened our forum, I said that, look, the protection of the development of competition exists in Ukraine for at least 25 years. But if we look at those efforts of Anti-Monopoly Committee only as an institution which needs to stop the violations, undoubtedly we have an opportunity to take part. According to the law, we are taking part in the formation of the competition policy of the state, but we are only taking part, not more. Our main task is to stop the violations and to control the concentration or the monopolization. But what I began with, Article 4 of the Law on the Protection of Economic Competition tells that the program of demonopolization and systematic work of the growth of competitiveness of the subjects is the issue of the branch institutions, ministries of the power. And what we invest lots of time into is, first of all, for at least those ministries to fix, to document that the priority of their work is the development of the competitive environment. Because the competitive environment and competitiveness, they look like each other, but they are different. They have a bit different sense. So if we say it systematically, our initiatives were formalized on the 1st of September. We've sent those letters from the ministries, claiming from them to implement certain events and measures on the monitoring of certain branches, reminding them that it's their sphere of responsibility as for the development of the competitiveness and competitive environment in certain branches. As I mentioned, the response was totally different from different ministries. But here I think that to bring everyone at the equal level of understanding of the responsibility, acknowledgement, recognition of a responsibility, that this ministry, not the Anti-Monopoly Committee, is responsible for the development, for instance, of the certain branch and of the competitive environment in that, and finding the certain indicators of efficiency as for the certain measures on the development of the competitive environment, of the anti-monopoly actions by all of the authorities all of those measures finally will be included into the strategic document of the development of competition, which we have to develop up till the end of this year and give it as a suggestion to the Cabinet of Ministers. From our side, everybody has to perform his or her own tasks. If we looked, before the beginning of this forum, we got an annual report. Here, in this report, you can see the principal change of the philosophy of the Anti-Monopoly Committee, in comparison with the reports which used to be before. The report of 2016 and 2017 are on purpose having the similar structure for you to see how we look at the problematics of the markets. We're doing that totally openly. You can criticize us, but to criticize not for the sake of the criticism, but to give certain suggestions. If you consider that certain markets have certain problematics which need the intervention of the Anti-Monopoly Committee, please do that. We're totally openly declaring which events and measures we're doing to change this situation. But I think, well, I don't want to say just empty speeches, political speeches, but I have high expectations on the work with the World Bank. This work is not as rapid as we dreamt of, but in the end, we must develop a document which, on the one hand, will create the system not only to adopt certain strategic documents by institutions at once, but to develop the work on the growth of the competitiveness and competition of the certain markets without the violation of the ad hoc principles of the principles of competition. Dear colleagues, first of all, I think that we need to thank the organizers of the forum and for their involvement of the guests. We really got lots of additional information and well-known information too. So I have a very precise question to one of the speakers. I mean Šarūnas, who said, you shouldn't interfere into the micromanagement, right? And you named the example with the chef. Maybe you had a nice dinner yesterday, and it was really pleasant for us too. But if we speak about the chef, maybe you are speaking about the production policy, but we are speaking about micromanagement, about the managerial organizational policy, about the policy of the management. So the role and the significance of the anti-monopoly institutions of the micromanagement. I do understand that the SME is anti-monopoly itself, but if we speak about the anti-monopoly state at the regional level, there is room to do for anti-monopoly institutions, but there is the second part, which is unfair competition. There is lots of room to improve there. And let's read the name of our panel, Inclusive Competition Policy. So it should be inclusive. So maybe I'm asking our guest from Lithuania, what should we do with the role and significance of anti-monopoly institutions at the level of micromanagement? Because you said that we shouldn't interfere. Well, I would say this is a debatable question, and honestly speaking, I don't totally agree with your sentence. Please. Before Mr. Šarūnas answers, so without the microphone we don't hear the question. The microphone, please. The microphone is not at the speakers. Thank you so much for this question. I will give the floor to Šarūnas, but look, unfortunately we are out of our schedule. So let this be the last question. Because all of our panel discussions are interconnected, you will be able to ask the question during the next panel discussion. So please, Šarūnas, answer, and at 11:30 we've planned the next panel already. So please, a very short coffee break for about 10 minutes after the answer of Šarūnas.
Okay, I'll try to do it quickly. When I talked about micromanagement, first of all, I had in mind politicians, that they should not micromanage the competition authority. But your point of to what micro level the competition authority should go is also very relevant. Because yes, you can have thousands of cases at a micro level, but you should always question, and that's what Bill talked about, you have experiences, then you contemplate your experiences, and then you improve upon them. So you should always question yourself, if you're only working or mostly working on the micro level, does that have impact on consumers and on economy as a whole? Sometimes it's better to have bigger cases, a combination of bigger and smaller cases, and that's the most efficient way to do. Because I think, and there is a trend for some authorities to go and do so much enforcement, which looks good in statistics, but if you look at the effect, not so much. And I think that's the challenge that URI and the AMCU is facing.
Я дуже дякую. Давайте дивіться, наступна панель, вона фактично прямо пов'язана по суті.
Is interconnected according to the topic of this one, the role of OECD and standards of OECD. So let us save our questions and discussion till the discussion of the next panel discussion. Now we have 10-minute coffee break. At 20 minutes to 12 we are beginning the next panel.